Hi, my name is Shannon Bradford. I'm here to talk to you, or Shannon Bradford McDonnell, sorry. I'm here to talk to you about guardianships and powers of attorney today and the differences and similarities between the two. Okay, so what is a guardianship? A guardianship is a legal relationship between an individual, the guardian, who has been given legal authority and duty to make decisions on behalf of another individual, which is called the ward after the guardianship is put in place, who lacks sufficient capacity to manage his or her own affairs and to make and communicate important decisions. Some frequent terminology. The disabled person, that would be the person that is 18 years or older who is not fully able to manage his or her person or estate because of mental deterioration, physical incapabilities, a mental illness, a developmental disability, a gambling or drug addiction, or fetal alcohol syndrome. And one thing to note is that you are not, or a person will not be designated a disabled person in a guardianship until the end. Throughout the court proceedings, that disabled person will be called an alleged disabled person. Once the guardianship has gone through, that quote unquote disabled person will be called the ward. So the ward is the person who's been declared by the court to be disabled and the person for whom you have been appointed as guardian. A guardian ad litem is a person, typically an attorney, who has been appointed by the court to look out for the ward's best interests. So it's kind of like the third party attorney that doesn't answer to the attorney seeking the guardian and doesn't, excuse my dog. Also, it doesn't, the guardian ad litem directly reports to the court. And directly represents the ward in this situation or the alleged disabled. A guardianship order is the court setting forth your powers and duties as the guardian. They can vary, but at the very least, a guardianship order accompanies letters of office, which are those court documents which confirm your appointment as a guardian. So there are several different types of guardianships. There is the guardianship of the estate, which deals primarily with the finances. So some examples of a guardianship of the estate: you might name a bank to do that if the estate is such that it needs running by an entity. A guardianship of the person deals with the choices and decisions of that person. So it's basically like standing in the shoes of that individual and making their day-to-day health, welfare, everyday decisions. As to where they live, if you make sure that they are eating and taking care of themselves. It's really like you are acting in the shoes of that person. Plenary guardianship is the guardianship that is the long-standing guardianship. It is the done deal. It is not temporary. Temporary usually comes before, but plenary is what is at the end of your journey in court. You would be seeking a plenary guardianship. Limited guardianship is just like what it says. It's limited. You would limit powers according to a certain circumstance. For instance, if somebody didn't have capacity in one sense but did in another, you would limit those guardianship duties. For instance, if they needed help making financial decisions, but they were able to make decisions about their person, about their health and welfare, then you could have a limited guardianship in that situation. A temporary guardianship is exactly what it says. It's a temporary guardianship. It's what you would seek in, say, an emergency situation. Let's say you want a plenary guardianship, but you need to get something put in place immediately. Let's say your mom is in a nursing home and they're about to release her, and you have no ability to make decisions for mom about where she's going or what's next, and your mom is limited in capacity. Then at that point you would seek a temporary guardianship, which would then you would also seek a plenary guardianship, unless by some turn of events your mother would regain capacity to make those decisions for herself. A successor guardianship is the person named after the guardian in place. So successor guardians are typically appointed whenever somebody is making their end of life plans. If they are doing that, while they're still in capacity of their abilities, their mental and physical capabilities, they could name a successor guardian. Just just preempting and knowing what could happen in the future. So it's really just naming that person that would success whoever the guardianship in place would be. In a lot of cases, successor guardian would just be the next person after yourself. Like I said, if you're making your estate plans, you would name a successor guardian, but it could also be in a court adjudicated guardianship. It could be somebody that is named after that initial guardian was named for a host of different reasons, whether that initial guardian could be sick, something could have happened where that guardian can no longer serve, and then that successor guardian would be the person in place. A testamentary guardian is somebody that is, they are named per a will, they are named per your estate plans, somebody that has been appointed preemptively again, whereas successor is the next person in line. Testamentary would be the person just appointed, point blank in your will. I am naming X to be my guardian if at such time I am not around to make these decisions. A lot of times you would see a testamentary guardian if you are making a will and you are trying to plan for how to care for your kids in case of your death. You would name a testamentary guardian of perhaps your brother or your sister or your mother or your father, somebody that could step in. So adult guardianships and alternatives. So this is where we'll talk a little bit about powers of attorney. Okay, one thing to note about powers of attorney just at the onset, a durable power of attorney is a power of attorney appointment that lasts even once the principal has become incapacitated. In powers of attorney, you have the principal, who is the subject of the powers of attorney, and you have the agent, who is that person that is being appointed on behalf of the principal. So again, a durable power of attorney is important because, the point of you doing this is that you want to protect yourself in case of incapacity in most situations. So a durable power of attorney implies and says that it's the appointment that lasts even once that principal has become incapacitated. Another thing to note is that a power of attorney is a fiduciary, so all decisions should be made using a best interest standard. This means that just because a power of attorney has the power to make a decision doesn't mean that he or she has the right. Every decision they would make within their realm of power would need to go through that analysis of, is this in the best interest of the principal in this situation? So there are several different types of powers of attorney. There's the financial property power of attorney, which gives the agent the ability to make financial decisions on behalf of the principal. It's common to appoint one person to act as an agent for both financial and healthcare decisions, but in some cases it may be wise to separate the two. A medical or healthcare medical living will power of attorney is also known as a healthcare power of attorney, gives a trustworthy friend or family member, also known as the agent, the ability to make decisions about the care the principal receives if they are incapacitated. Mental health treatment power of attorney is pretty self-explanatory. It's within that realm of mental health treatment. So you would have that agent making decisions regarding the principal's mental health treatment, plans going forward, anything dealing with mental health treatment and care. Education power of attorney is also pretty self-explanatory, but it comes into play, let's say, if you have a special needs child who's getting IEPs or anything where there's a special circumstance where there needs to be somebody making those decisions on behalf of the student. It could also be in a situation where mom or dad feels that they don't have the wherewithal to make certain types of decisions, so they might appoint grandma or somebody else that they could make, that could be designated as the authoritative person to make decisions on behalf of the student in an IEP setting or whatever it might be. If you're trying to get special access to certain benefits for a special needs child in an educational realm, that's where a power of attorney would come in. A representative payee, that's the most common place that comes in is obviously a Social Security situation. So whenever there needs to be somebody else accepting the payment on behalf of that principal, you would go to Social Security, fill out the requisite forms, go through their background checks, and then be named the representative payee to accept payment on behalf of the person who is designated as able to receive Social Security benefits for whatever reason they are granted access to those funds. Okay, so does the principal have the capacity to sign powers of attorney? Well, so this is actually the cornerstone difference between guardianships and powers of attorney. You cannot have a guardianship without incapacity in some realm, whereas in a power of attorney situation, you have to have capacity in order to initiate them in any situation. Otherwise, they're going to be challengeable. They could be voidable. So the principal absolutely has to have a capacity to assign and appoint powers of attorney. Okay, so this is just a thought process, a little confusing. I apologize if it's hard to follow. But if he or she, I guess if he or she does have capacity for powers of attorney, will he or she sign them? Well, that assuming the principal doesn't want to sign them, the principal doesn't have to sign them. So if there is a situation that exists where you are trying to get powers of attorney entered, let's say on behalf of your mom, and your mom will not sign them, and you know something's going on that will hinder her health care or her finances, and it's to the point where you know she cannot make those decisions for herself, that's where you're out of the powers of attorney realm, and you need to be looking at the guardianship options. Because again, the difference between the two is that powers of attorney, it implies a level of free will and definitely a level of capacity, whereas the guardianship situation means that you've gotten past that point and you need to be making decisions for that principal because they are no longer able to do so. The next part of this says, will he or she allow you to act, or will he or she terminate and void the power of attorney as soon as they can or when? So again, this is the difference, is that, when you have powers of attorney, if you are the principal initiating those powers of attorney, you can change them all you want. You have the capacity to do so, so long as you are not in an incapacitated realm. So if you are just trying to get your affairs in order and you are creating your powers of attorney and knowing that you want somebody making those decisions for your finances and your healthcare and your advance directives for how to deal with your end of life wishes, then you have the ability to change those. And you can imagine all the different reasons why you might need to change them. Perhaps that person that you designated is no longer living. Perhaps something came up where you don't feel that person is trustworthy as your fiduciary. But the powers of attorney has you do, so long as you are still of capacity, you have the ability to change them. You can also write powers of attorneys to well, you cannot, it's powers of attorneys are not of the type of legal document where you should be prohibiting your free will. That's getting more into a guardianship situation. So a powers of attorney document, like say for your finances, you wouldn't necessarily be restricting your powers. You'd be giving those powers to somebody else to make the decisions on your behalf in your best interest. So it really shouldn't be a situation where you're prohibiting the principal from doing anything. Powers of attorney, you can end up in a situation where the principal remains vulnerable only if you are in a situation where you didn't cover all your bases. So let's say you did your end of life directives and you have your medical power of attorney in place, but now you have all of these different financial decisions that are up in arms. People are fighting. Maybe your kids are fighting. Maybe other family members are fighting. That's where it could become a vulnerable situation. And if you are at that point where you're not able to figure those things out for yourself, you could very well be in an incapacity situation. So that means that if you have no more capacity to be able to make those decisions, other people are all over the place about it, then that means that you're in that guardianship realm already. And obviously, if you are seeking guardianship, you are trying to prevent any sort of decisions being made that would make you more vulnerable. So what if he or she has capacity to sign but refuses to sign or doesn't want you as an agent? Well, again, if we're talking about powers of attorney in this situation, then that's if so long as that person has the capacity, they make their decisions over their own welfare for obvious reasons. You don't want to take somebody's liberty away without the necessity to do so. If that person doesn't have the capacity to sign, then you shouldn't be dealing with powers of attorney, period. You should be looking at guardianship. And if there is something that needs to be brought forth with how to deal with a person's health, welfare, care, finances, and that person is no longer able to make decisions, then yeah, the guardianship realm is where you're supposed to be in. If you just can't help getting himself or herself into trouble, legal, financial, criminal, personal, or medical health related, this is a tenuous situation. So if it's because of some sort of underlying condition, let's say somebody doesn't have the intent, doesn't have the capacity to be doing this, then obviously a power of attorney situation, you've left that realm, you're into the guardianship realm. But a troublemaker is not necessarily somebody who lacks capacity. So you can't just get a guardianship in a situation where your child is causing you a lot of stress and won't make good choices. Obviously, that's not going to work. We're talking about a situation where that person has neither the intent nor capacity to be knowing that they're getting themselves into legal, financial, criminal, personal, or medical and health related trouble. If a person is a danger to himself or others, then you'd be looking at a guardianship situation. And if it is of an immediate situation, you would be seeking an emergency temporary guardianship with plenary in the case that incapacity or whatever disability is causing that danger to himself or herself or others isn't going to stop. So if there's a disability that exists that makes somebody a danger to himself or herself or to others, and that disability isn't going anywhere, then you can rest assured that you should be seeking a plenary guardianship. Will powers of attorney be enough? So if the situation is that he or she is on the computer buying things with mom's credit card, probably not. In that situation, I guess it really matters on why he or she is on a computer buying things with mom's credit card. I mean, you don't ever want to just, in all things, legal, court related, you don't want to go to the most abrasive, the biggest action you could take without looking at all the different things you could do on a practical level to prevent court, to prevent adjudication, to prevent, judges, lawyers, all of that stuff. So if this is a situation where mom just, changes her credit card and can make practical decisions to prevent these sorts of things from happening, then that's what mom should be doing. If this is a situation where he or she just literally doesn't have the capacity to know that they are doing this, maybe they are being told to do things by a third party that doesn't have their best interest in heart, and this person has some sort of real cognitive or physical disability that keeps them from making, decisions that could somehow be related to mom's credit card, then you might be talking about a guardianship situation. But it sounds like this is one of those practical things where you need to be making those observations about how you can keep mom's credit card from being used, period. What if he or she announces that he or she is getting married or moving in with a friend? Well, one thing to note is that, let's say you had a guardianship in place. If you had the ward in this situation, who is the person who has a guardian, if that person told you that he or she is getting married or moving in with a friend, first of all, marriages and divorces, any of these types of things would be something where a court would have to make those judgment calls. So if he or she did that, then that would be a situation where if you had a guardianship in place, you would be seeking the court's involvement at that point to make the decision with probably a guardian ad litem as to whether or not the guardian or the ward in this situation should be getting married and should be moving in with a friend. It doesn't seem, just in the guardianships that I have been involved in practical knowledge, it doesn't seem like that is going to be something that would be approved without having a lot of extenuating circumstances, just because it implies that there's a certain level of capacity there that wouldn't be there if you had the guardianship to begin with. Now, if you're dealing with powers of attorney and a person announces that he or she is getting married or moving in with a friend, I mean, that's it. it depends on what the powers of attorney are. Let's say that it's your dad. He's designated you as a financial power of attorney, and he has decided he's getting married late in life, and he's going to do that. Well, then he has the ability to do that. I mean, it's not as if he is incapacitated, and unless a doctor or somebody or a court has adjudicated him incapacitated, then it really wouldn't be something where your powers of attorney could keep him from doing that. Again, powers of attorney are something that do not limit personal freedom. It's that person who is seeking a power of attorney. It's that principal seeking somebody else, giving somebody else the authority to make decisions. So if it limits personal freedoms and that person has capacity, it's powers of attorney are not going to be something that will stick. What if he or she refuses to have parents at an IEP meeting or is tricked? If you had powers of attorney for an educational situation, and I guess the person running the IEP meeting would, I guess it also depends. I mean, this is one of those things where it would really depend on the facts of the circumstance. So if you had a child, obviously this would be pretty egregious if they're having an IEP without guardians involved, meaning your parents or whoever the person taking care of you is. So this would be a really tenuous situation. It's fact specific based on how old that student is and what the situation is as to why that powers of attorney for education is involved to begin with. What if he or she goes for a driver's license test and you said no? Again, a power of attorney does not limit freedoms. If you are worried about capacity, you would be seeking a guardianship. Meaning if you really thought that person didn't have the wherewithal to be making those types of good decisions, then you would be at that point of saying this person doesn't have capacity to make those decisions. What if he or she is being asked to sign on, let's see, as a guarantor on a mortgage or any sort of legal document? That's something where powers of attorney, you could definitely step in and say no, because the person hasn't done anything. But if you are the designated financial power of attorney, let's say you're the financial power of attorney and the person who is your principal has children that are trying to seek money from them illicit, against their best interest, then you as the financial power of attorney would have the ability to say absolutely not. I'm POA in this situation, and I have the ability to contest this if something should come up. So it does give you protection. It gives the principal protection in that situation as well. Basic duties of the guardian of the person. It means that person designated the guardian will be responsible for the personal and medical care of the ward and may have the actual physical custody of the ward's minor children, and any adult children who are dependent on the ward for support and care. It means that the guardian will need to make decisions for the ward relating to personal care, health care, and living arrangements, and will need to file written reports with the court. And again, the guardian comes about because the court made that decision at the end of the day. It means that you involved the court. And the easiest way to think of the guardian of the person is that you are stepping in the shoes of that individual. So you make the decisions that person would be making. Limitations on the guardian of the person. There are specific things that a guardian cannot do without specific permission of the court. Court order will be required before you can place the ward in a residential facility, such as a nursing home. A court order will be required before you consent to any sort of sterilization procedure. A court will need to authorize the guardian to petition for divorce on behalf of his or her ward if the court finds it is in the best interest. It may also authorize the guardian to consent to the ward's marriage. So basically, once you have a guardian of the person in place, major life decisions will need to be approved by the court. And it's not that it's a long, drawn out process to seek that approval. It's more for the fact that once you become the guardian of that person, you are liable for making the decisions for that person. So it's not only in the best interest of the ward, but it's also in your best interest, so that in the future, you have this record of going to the court, letting them know what's going on, and that judge, finding that it was in the best interest. You have that backup to defend your own decisions that you made on behalf of the guardian. a lot of this can also be written in, especially let's say you're trying to seek a guardianship of the person. Again, let's say your mom is about to be released from some sort of residential care facility. There's no backup plan. You don't have any power put in place, and you need to be able to make decisions for mom to get her into a long-term care facility. In that situation, you would be seeking that. And let's say mom also has the type of incapacity that is not going to get better, some sort of illness, maybe it's dementia, maybe it's Parkinson's, something where she's not going to be snapping out of it anytime soon, unfortunately. So in that situation, you'd be seeking a guardianship, probably temporary, because you would probably need some action pretty quickly. And then you'd also be seeking that plenary guardianship for long-term ability to make those decisions for mom. In that situation, you could be writing this in, especially again, if you're trying to do it for the purpose of making sure mom's getting into a long-term care facility, you would write it into that order for guardianship. And the court would look at that and they would be okay with that, because you would be explaining, where you're putting mom, what you're doing. So a lot of times, although you need court approval to do these things, you know what you're going to need before it even happens. So you can write it into the order to be prepared. Basic duties of a guardian of estate. This is where I cut myself off because I was getting a little too ahead of myself. Basic duties of the guardian of the estate include filing an inventory of the ward's assets. You would file that inventory with the court, and if you had an attorney in the situation, your attorney would be the one letting you know, hey, it's time to be doing this. I'm sending you the template, need you to fill it out. The attorney would look over it, submit it to the court. And again, it's because you are liable for those decisions. You are stepping into the shoes of that person making their financial decisions. So you need to be telling the court how you're spending the ward's money. You'd keep the ward's assets and income totally separated from your own assets and property. Practically speaking, this means that you get a separate checking account and perhaps a savings account, but for the daily expenditures, you would certainly have a checking account in the ward's name alone, so that there is no question about commingling funds or what was spent on who and where and how. It's good practice, and it's something that you need to do if you are trying to get the guardian of the estate. You need to be prepared to do that. Well, here we go. Open an estate checking account with your name as the guardian for the receipt of the ward's regular income and for you to use for payment of the ward's bills. Again, you just need to have something so that you're not commingling funds, because that is absolutely against, the ward's best interest, and is against what you should be doing as, practically speaking, for the decisions that you're making as the guardian of the estate. As the guardian of the estate, you would contact all sources of the ward's income, such as Social Security, Department of Veterans Affairs, or any pensions and employers, and request that the ward's checks be sent to you and the estate checking account. Another thing that you should know if you are trying to seek a guardianship of a person's estate, it is your duty to be seeking benefits. If you know that the ward used to be a VA and could be getting certain VA benefits, then you do have a duty to be doing some research on that. Obviously, if the cost outweighs the benefit, that's one thing. But you do have that responsibility to be making sure that you are taking all benefits that you can try to get to benefit your ward. What I was going to say on the prior slide with the guardian of the person is that there are some things that you will also need to seek the court's approval on, and that would be like if you're selling you're selling the ward's home. In that situation, you would need to seek the court's approval of the same, and you would do it once you're in practice that you're ready to sell the house. Again, practically this comes up whenever you know that the ward is going to be entering some sort of long-term care facility. You know that the house that he or she used to live in is no longer going to be lived in by the ward or anybody else for that matter. So it's in the ward's best interest to sell it, because that's an expense that ward could be. It's an expense that could be totally eradicated, and that money could be used to be taking care of the ward instead. So it'd be in the best interest to sell the home. But before you can do that, you do need to get the court's approval. And practically speaking, again, you would do that at such time that you are really willing to sell. So it's on the market, you have a sales price, you have perhaps, ideally you would have that contract for sale, and then you would let the court know, this is what the fair market value is. You would let the court know all those practical facts that lets the court know that you're not just getting rid of the house, you're trying to sell it, in the best interest of the ward for value that it is worth. Moving or going forward with some more of the responsibilities of a guardian of the estate, you would be sure the ward's real estate and other assets are securely protected and maintained, and you are allowed to seek, third parties that know how to do that better than you. This is why sometimes you name a bank to be the guardian of the estate. Let's say somebody has a large financial profile, then you want to make sure that it is in your best interest, it is in your ward's best interest, obviously, to be trying to find those people who know how to deal with that estate, the estate better than you perhaps know how to. You have the duty to manage and invest the ward's financial resources. Again, you can seek somebody who knows how to do this if you don't know how. You would also respond to any legal matters concerning the ward and be sure that he or she is represented in court proceedings. You pay the ward's taxes and apply for applicable public benefits and file a written account of all financial transactions which you make on behalf of the ward, setting forth all income received and expenditures made on behalf of the ward. And again, that last part, which has to do with the financial accounting, that's something, if you have an attorney, that attorney is going to stay on top of you for that to make sure that you're fulfilling your obligations according to the court's timelines. And again, I do want to reiterate, whenever you have the type of estate that is substantial, it really is something to explore that you would be seeking a bank or somebody who is well versed in financial planning, so that you know that ward is getting taken care of in their best interest, that their estate is being taken care of and it is going to flourish instead of be harmed. As the guardian of the estate, there are certain things that you cannot do without specific permission from the court. You will need to file a petition with the court and probably notify the guardian ad litem, if there is one appointed, before you transfer or sell the ward's personal property or estate or real estate, mortgage real estate, or take out loans on the ward's behalf. We talked a little bit about that a couple slides back. Make any gifts from the ward's estate, expend any large sums of the ward's money for expenses, and distribute any money to yourself or anyone else for guardian fees. Again, you do this through a petition, or a motion. You would seek for approval for allocation of funds. It's not daunting, it's not horrible, it's just a matter of doing your accounting and getting it done. So again, if you had an attorney, your attorney would guide you as to what you need to file, when, and what's necessary to do so. Terminating the responsibilities of the guardian. Once a guardian is appointed, only the court can terminate or modify the terms of the guardianship. These circumstances may include the death of the ward or the guardian, the resignation of the guardian, and restoration of the ward's rights, terminating the adjudication of disability. So practically speaking, unfortunately, the restoration of the ward's rights is not something you see all too often. But what happens oftentimes is that you will need to transfer the guardianship because somebody is maybe the ward is moving to a better climate and they're moving with their guardianship or their guardian. Then you would need to transfer the guardianship at that point. Let's say you're moving states from like Illinois to Florida. Then you would need to petition the court in the county to which you are moving in Florida, let them know. Then you need to work with the court in Illinois to have that guardianship transferred so that both courts are aware of each other and they are all on the same page as to what's going to happen with this guardianship. Obviously, death is the number one reason why you would terminate a guardianship. Resignation often happens because, let's say, that guardian it becomes ill or can no longer perform their duties. Then you need to be, terminating the guardianship or assigning a successor guardian. Okay, do we have any questions? Okay, some of the questions. Is the guardian ready for the job? Again, guardianship is a big responsibility. You don't take it lightly because it's like you're choosing to care for not only yourself, but somebody else. So, and whenever, again, if you have a guardianship in place, you're in the courts. So you have, a judge overseeing your decisions. So to take on that type of responsibility, it really is a big decision, and you need to be dedicated and able to be there physically if necessary, to be there to make all those hard choices that you might not want to make. Obviously, the type of relationship between the guardian and the ward can be a factor that you want to consider. I mean, sometimes it's hard to make those decisions. Sometimes you have family members that are going to make a guardianship situation a nightmare, just practically speaking. A guardianship is not something to be taken lightly, and if you do it, it's definitely a task to undertake. So yeah, are you ready to be on call 24/7, 365? Again, if you're stepping into the shoes of that person, that means that, your job doesn't just end because it's nighttime or what have you. If he or she is a danger to others and or property, could the guardian be liable? A guardian takes on liability on behalf of the ward. So if there is something where you are allowing that ward to be a danger to others, you could definitely be liable. You could be brought into court for shirking your duties, quite frankly. So that's why you need to be able to be the guardian. That's why you don't do it lightly. Can the guardian limit any liability by only seeking emergency, temporary, partial, limited guardianship? Yes and no. I mean, if you are seeking an emergency guardianship, then if something still happens during the terms of that emergency guardianship, then you are on the hook for that. Just because, and even with a partial or limited guardianship, that's arguable. You could try to limit that, and that's also limiting the guardianship for the ward's interests, not yours. It's not limiting your capabilities. It's to try to preserve as much freedom to the guardian as possible, or to the ward as possible, because obviously if you are in a guardianship realm, that means that you are taking away the liberty and freedom of that ward for whatever reason it might be, whether it be disease, whether it be dementia, whatever it is. It's a big step to have a court say, this person can no longer make decisions for themselves. So it's, a guardianship is not meant to really protect you as much as it is to protect the ward. One thing that is important to note is that whenever you are seeking a guardianship, you might seek out bonding, and to be bonded is obviously a tedious process. A lot of times the court will require it of you. Sometimes it can be waived. A lot of times it can be waived, in fact. But the point of being bonded is that it protects you whenever, let's say you have a guardianship in play, whenever the guardianship in play where the person that is incapacitated has family members that are just, they're going to make your life hell. And let's say you've been advised by your attorney that this is probably, they are going to make your life hell. They're going to drag you in court. They're going to be ready to, accuse you of anything. This is not necessarily a rare situation. Then you would want to get bonded so that you could have that in place should you ever need to defend yourself. Can the family hire a company to act, or a public guardian? Yes, you can. Sometimes a public guardian will be appointed if there's a situation where none of the family members are deemed proper guardians, or in the guardians that would act in the best interest of the ward, then a public guardian can be appointed. Obviously, in an ideal situation, you don't want to have a public guardian, because a public guardian, they take the same oaths, they have the same responsibilities, but they're a public guardian. That means that you are not their only charge. You're not going to be getting the same type of attention that that a ward should ideally have. In a guardianship situation, you really want that person who's being designated the guardian to be ready, available, and willing to be that full-time person for you. So public guardian, just by the simple fact that they can't be everywhere at once, you're not going to be getting the same time and attention that you would if it was a family member or a trusted friend that was appointed. Can a family hire a company? That's what comes into play whenever you have that type of estate that really requires some very detailed care. If you have an estate that is, $2 million, then you don't want to just have your friend dealing with it who has absolutely no assets to speak of and doesn't know what, the difference between an annuity and a checking account is. So in that situation, you can definitely seek out a bank to be the guardian. One thing to note is that just because you designate somebody doesn't mean they have to accept it in that situation. So you should always, always, always do your due diligence to make sure that whoever you're appointing is willing and able to serve. What if the ward needs a guardian but no one steps forward? Unfortunately, that happens often, and that's where a public guardian does come into play. Whenever there's no one else, you would seek out a public guardian. although public guardians often come into play whenever somebody is insolvent, doesn't have money, it's usually a pretty detail or fact specific situation. But if the ward needs a guardian, no one steps forward, you can seek a public guardian and the court can appoint a public guardian. All right, well, that brings us to the end of the webinar. Thank you for attending. If you have any questions, you are more than welcome to email us at info@civialaw.com, and our number is 618-659-4499. And again, I'm Shannon McDonnell. Thank you for spending some time with me.